Placement. There are a lot more things that the court has to look at now on the issue of placement. And of course, detention facilities can never be used because the department cannot locate the placement for a teen. And of course, this is why I have highlighted this, the word shall. When you see the word shall in the code, it is mandatory. May is permissive, shall is mandatory. The department shall provide frequent visitation where siblings are not placed together unless there's documentation as why it's contrary to their interests. So not only do parents need to be visiting with children, but sometimes we will get sibling groups as large as 9. It's hard to find a foster home to be able to put 9 children in. It's very likely to split them based upon ages. And if that happens, then we have to make certain that those children get the opportunity to visit one another. All right, so again, the implementation issue on visitation is the absence of foster homes, particularly those that can take large sibling groups, no funds for visitation, and then the risk that if we make the no reasonable efforts finding, there will be even less money for the system. The first hearing that we have after we've done removal is the preliminary protective hearing. It's basically what you would call in the past a detention hearing, and you have to have this hearing within 72 hours. Everything in the juvenile court is fast. We get a call, we have to have the hearing scheduled within the 72-hour period. We have to make findings. Probable cause that there is dependency. And again, this is where your no reasonable efforts comes in. And then our timeline is incredibly fast. Once we've had that hearing, if the child is in foster care, the petition has to be filed in 5 days. If the child is not in foster care, there's a 30-day period. This is what goes into a petition, and it's not a whole lot different from the past, but what is different is the notification to relatives. Adjudication is the hearing that follows the removal hearing. This is your fact finding. In juvenile court, there is no jury. The judge is the fact finder. And in adjudication, the petitioner has the burden of proof, which is the Department of Family and Children's Services, and a thorough hearing and thorough findings are really important because the adjudicatory hearing decides what the issues are as to why the child is not safe at home, and then sets the plan for the rest of the case. Because out of the adjudicatory hearing comes the roadmap, the case plan of what is necessary to get this child home. This is the defects report, the case plan. It's due within 30 days of removal. A 14-year-old child, of course, has the right to participate and have a copy of it. And this time we have to include the dissent and the recommendations not included in the plan so that the court gets the whole picture. Here are the implementation issues. Our case plans are comprehensive, but the format is difficult. If someone handed you that, I doubt that any of you, even with your degree of education, would understand precisely what it would mean to you. It's long, it's not, sometimes it's incomplete, sometimes it's inaccurate. The format for it is not flexible. And it is the roadmap home. If the case plan is bad, if the case plan is vague, if the case plan misses the issues, then we are slowing permanency for children because we don't have a good roadmap home. It's probably expensive to solve these problems, but as technology improves and we have more flexibility, it should be cheaper and easier to solve. But in the meantime, I will tell you that Judge Tilley has a great little thing that she breaks out, and it's a really simple worksheet where you write down exactly what you're to do, step 1, step 2, step 3. This is another issue. Not every case should be a reunification case plan, and it takes somebody bold to step up and say, we don't think this needs to be a case where a child goes home. And when that happens, a report for non-reunification is filed, and certainly there's a right to have a hearing and dispute that. But here's the long-term issues and the reason that we have to think about every case separately and independently. We need to assess for parental ability at the beginning of a case. It is absolutely inappropriate to start a case knowing that parents have very, very limited skills, no support system, and no likelihood at all of achieving reunification. But some reason, our caseworkers, our attorneys, our guardian ad litems, and many judges think that's required. It is not required under Georgia law. It is not required under federal law. So, to make sure that we're doing our work right, we need to know, do they have the ability to learn and change? We absolutely have to look at substance abuse. 80% of our cases, or more, will have substance abuse issues. Domestic violence will be present, but domestic violence will not come out in the beginning. Domestic violence only comes out after trust is built. Mental health. 2/3 of the 80% that have substance abuse issues will have a co-occurring disorder. And if we don't treat both, we're never going to be successful. We have to continue to assess, because children don't talk until they trust. Parents don't talk until they trust. And then we need to modify our case plans when we learn the new issues. So here's our implementation issues. Training, 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 training. We cannot waste 12 months of a child's life. We're not talking about 12 months for us, 12 months for an adult. We're talking about what it's like in the life of a child who may only be a year old, who may only be 6 months old, who may only be 3 years old. And then the other big training issue is to be able to work 2 plans at the same time. The law is clear. We have to have plan A and we have to have plan B. How many of you in this room are parents? Raise your hand. Okay? I'm assuming as a parent that you've made a will that if something happened to you, you know who you want to raise your children. Why do we not insist on that in our courts? We have to have plan A, which is typically reunification. But we have to always be working plan B and having the plan B people at the table working with us to know this family. We never know when someone is going to become ill and not be able to parent. We never know when someone is going to be killed in the course of our jurisdiction and never return to our court. We have to be willing to work these cases together at the same time. The law is clear that we can do both at the same time. And it really makes things better for the child because there are more adults involved in the child's life. And then if reunification fails, there's not a delay. We've already established the relationship. Case plan contents. Here's an important part of the code. The least restrictive placement, the most family-like placement in close proximity to family and school. We are not doing this. This is very important. So, new code requires stability of education. We do not map removals. We do not recruit our foster homes where we're doing our removals. And we don't map our school districts. We're in a time of technology when this would not be difficult to do, so why are we not doing it? We don't have enough foster homes. This is the 3rd time, and I'm going to keep saying it. We do not have enough foster homes in our districts to have the stability. And we don't have funding for transportation with DHS or with the Department of Education so that they're outside the district to be able to reimburse foster parents to take them to their home school. We have limited services for respite and limited support for foster homes who are in danger of disrupting. And everybody needs time off. If you're parents, I'm sure that you take your children to grandparents and have time off. We need to give our foster parents time off and not drive them off. All right, reasonable efforts are not required when we have horrendous cases. So I want you to know that the law recognizes there are times when there's been aggravating circumstances where you really should not make reasonable efforts to avoid removal. And I've talked about non-reunification. Okay, disposition is the hearing after adjudication. This is where we take the case plan, make it an order of the court, and we lay out what it is that everybody has to do. And our timelines are fast, 72 hours, 5 days for the petition, adjudication in 60 days, disposition in 30 days. We are not like other courts where stuff takes years. This stuff has to move fast. Relative search, you have done a great job in the legislature of laying out what it is, how it gets done, making sure that we're thorough and that we are doing everything we can to find relatives for a family or for a child. It is to be completed and filed before the final disposition. It's to be written and filed with the court within 30 days of removal. But be careful. There's one place in this statute that I want to talk about. We used to do diligent search after termination of parental rights, which, of course, was backwards. You need to do it at the beginning of the case. So we changed the law, and we did diligent search at the beginning of the case. But under the new code, we've got diligent search throughout the case. This is a bit of a risk, and this is why your training and your practice has to think about. I am forcing the issue of diligent search in the first 90 days of the case. And the diligent search, there's an obligation to continue, but if that child has already attached to a foster parent and you haven't made a finding of diligent search, and then you get to a year and all of a sudden a relative that's a stranger to the child comes up, then you're going to have the problems we had with the old style of the law, of having to remove a child that's formed a secure attachment and start over. So we're going to have to, as a practice matter, make a finding that we've conducted the diligent search, we've identified the names, so that if we make a decision to go with a non-relative, there's a legal basis that is appropriate. So this is a very big training issue. Interstate compact for children takes too long. This is an easy thing. We can automate the process to go from the county office to the state office and work with other states to see if we can automate it to go to other states. This is an easy win at the state level. It's an easy win at the federal level. There's no reason with technology that we can't speed up the process. And no, I am not asking people to barcode children, because I've always been fussed at for wanting to automate this process. But I think it's very important for us to speed up. Interstate compact of children is really important. If we have children we have relatives in Alabama, and the family's in Columbus, and they're like maybe 2 or 3 miles from one another, we can't make that placement. Because our children are on Medicaid. If we make the placement in Alabama, they're not going to be able to continue their Medicaid. They're not eligible for Medicaid in Alabama because they're Georgia children. We can't keep them on Georgia Medicaid because they're living in Alabama. They can't get Medicaid in Alabama because we didn't go through interstate compact. So that's why this process is so incredibly complicated, but it's so incredibly important. Children have the right to have that medical insurance, to have those services, and if we don't follow the law, they don't get the services. Okay, this is really important. The statute specifically says the burden is on the department to recruit, identify, and make a placement in a home that can be permanent if reunification fails. So that means a lot of our foster homes need to be potentially adoptive homes, and not recruiting foster homes that specifically are saying, I'm not interested in permanency. Notice of change of placement was maintained in the new code, and that's to let everyone know when a child has moved and why they've moved. We have review hearings. We have to have one 75 days from removal. Then we have to have the next one at 4 months. The focus is on the child's health and the child's safety, but it's also a period of time where you're giving a report card to the parents. You're determining what they've done on their case plan, you're expanding visitation, and you're looking at whether you're making progress toward reunification. It's very important that we have code that says when there's a lack of substantial progress, the court shall order the department to begin the non-reunification or concurrent plan process. Shall is mandatory.